You dying of mesothelioma. You sued the company that poisoned you. And then, on a Monday afternoon in 2017, that company vanished. Not into bankruptcy, not into hiding, into Texas for 5 hours. Then it left. By dinner time, your lawsuit was frozen. 9 years later, in mid-2026, you still haven't seen a dime. This is the story of how a paper giant used a single sentence of obscure state law to lock 64,000 cancer victims out of court without ever moving a single desk. Let's start with the lie buried in the headline. People say Georgia Pacific moved to Texas. It didn't. Georgia Pacific's headquarters has sat in this 51-story tower in downtown Atlanta since 1982. The executives never packed a box. What moved was a piece of paper. In American corporate law, a company has a physical home and a legal home, and they don't have to match. Georgia Pacific's legal home, the state whose laws govern the company on paper, was Delaware. On July 31st, 2017, a lawyer filed a form changing that legal home to Texas. It was a domicile flip. Nothing else changed. Same building, same employees, same toilet paper rolling off the same machines. Why bother? Because Texas has a law that exists nowhere else in the United States, and Georgia Pacific needed that law for exactly one afternoon. Here's the problem they were trying to solve. Between 1979 and 2017, Georgia Pacific spent over $2.9 billion defending itself against asbestos lawsuits. The company's old building products, joint compound, ceiling tiles, were laced with asbestos. Workers inhaled it. Decades later, their lungs turned to scar tissue. They sued. By 2017, 64,000 of those lawsuits were still pending, and the cases kept coming. So Georgia Pacific's lawyers reached for a tool tucked inside the Texas Business Organizations Code, Section 10.008. Now, in almost every state, when a company splits itself in two and shoves all the lawsuits into one half and all the profits into the other, the law calls that a transfer. And transfers can be undone. Fraudulent transfer law is the rule that stops a debtor from giving the family silver to their cousin the day before the creditors knock. If a court finds the transfer was designed to dodge liability, it claws the assets back. But Texas Section 10.008 contains an extraordinary phrase. When a Texas company splits itself in a divisive merger, the statute says the assets and liabilities are divided, and this is the magic phrase: without any transfer or assignment having occurred. No transfer. No transfer means no fraudulent transfer law. The clawback tool just doesn't apply. This is the entire game. So at hour 1 on July 31st, 2017, Georgia Pacific converts from a Delaware LLC into a Texas LLC. Now Texas law governs the company. At hour 2, it triggers a divisive merger under Section 10.008. It splits itself into two brand new Texas entities. Entity number 1 is called Bestwall LLC. Bestwall inherits all 64,000 asbestos lawsuits. It gets $32 million in cash. It has no employees, no factories, no products. It exists to absorb dying people's lawsuits. Entity number 2 is called New Georgia Pacific. New GP gets the factories, the brands, Brawny, Dixie, AngelSoft, and the billions of dollars of annual revenue. It gets 0 lawsuits. Then, at hour 5, both entities convert out of Texas. New Georgia Pacific re-domiciles in Delaware. Bestwall registers in North Carolina. Total time these companies existed under Texas law, under 5 hours. The Texas part is over. The Texas law has done its work. The no transfer magic is locked in. 3 months later, November 2nd, 2017, Bestwall files for Chapter 11 bankruptcy in Charlotte. Now think about what bankruptcy does. The second you file, every lawsuit against you freezes. It's called the automatic stay. It's meant to give a genuinely broke company breathing room to reorganize. Bestwall isn't broke. Bestwall has no operations to reorganize. But on paper, Bestwall is a separate company holding 64,000 claims and only $32 million. So the bankruptcy court grants the stay. Then the lawyers ask the judge for something more. They ask the judge to extend the stay to protect New Georgia Pacific too, the profitable parent that isn't even in bankruptcy. Their argument: New GP has signed a funding agreement promising to bankroll Bestwall's eventual settlement trust, so the victims will get paid eventually. Suing the parent now would just disturb the process. The judge agrees. And just like that, 64,000 lawsuits against one of the most profitable subsidiaries of Koch Industries are frozen indefinitely, even though the parent company is financially fine. The Seventh Amendment guarantees a right to a jury trial in civil cases. Bestwall and New GP found a way around it, using nothing but a domicile flip and a bankruptcy filing. This is the Texas two-step, and the moment it worked for Georgia Pacific, the copycats arrived. Johnson & Johnson did it to escape tens of thousands of tout cancer claims. 3M did it for military earplug lawsuits. Saint-Gobain did it. Trane Technologies did it. Every one of them took the same 5-hour Texas detour. In 2023, a Fourth Circuit judge named Robert King wrote a furious dissent calling the Bestwall arrangement a manufactured sham, a boardroom maneuver, in his words, designed to extract cheaper settlements from suffering and dying victims through pure delay. But in October 2025, the full Fourth Circuit voted 8-6 not to rehear the case. The two-step survived. In February 2026, the asbestos claimants petitioned the U.S. Supreme Court. Their argument is simple. A company that isn't actually in financial distress cannot use bankruptcy as a shield. That petition is pending. And then, in April 2026, the strangest twist. The Wall Street Journal reports that Georgia Pacific is abandoning Bestwall. After 9 years of litigation, after hundreds of millions in legal fees, after thousands of claimants have died waiting, $0 paid out. Zero. The company is now preparing a fresh Chapter 11 through a different affiliate to try to force a quick settlement. The escape hatch became a trap for everyone. Here's what's worth holding on to. The Texas two-step didn't require new technology. It didn't require fraud. It required one sentence in one state's corporate code, executed over one afternoon by lawyers who never had to leave Atlanta. The American mass tort system, the thing that's supposed to make corporations pay for the harm they cause, was rewired by a domicile filing and a 5-hour layover. Somewhere right now, a corporate lawyer is reading a state statute looking for the next sentence like Section 10.008, the next loophole that lets a profitable company bleed time